Separation of powers alone, just dividing government into three branches with different functions, isn't sufficient to prevent tyranny. Montesquieu recognized that truly protecting liberty requires specific, concrete mechanisms where each branch can actively check, limit, and constrain the other's power. This is what we call checks and balances, the practical tools each branch uses to prevent the others from becoming tyrannical. Let me walk through systematically how these checking mechanisms work in each direction. How the legislature checks the executive. First and most fundamentally, the legislature controls government funding. This is sometimes called the power of the purse, and it's enormously important. The executive cannot act without money. Want to enforce laws? You need to pay enforcers. Want to maintain an army? You need to pay soldiers. Want to administer programs? You need to pay administrators. Only the legislature can authorize spending. If the executive defies the legislature or exceeds constitutional authority, the legislature can defund the executive's operations, effectively paralyzing executive action. This gives the legislature tremendous leverage over the executive, even when it cannot directly command obedience. Second, the legislature can investigate executive actions. Legislative committees can summon executive officials, demand documents and testimony, expose wrongdoing, and bring public attention to executive abuses. This oversight function makes executives accountable even between elections. The threat of investigation, public embarrassment, and political consequences constrains executive behavior. Third, the legislature possesses the ultimate check: impeachment and removal. If executives commit serious misconduct, treason, bribery, abuse of power, betrayal of trust, the legislature can literally remove them from office through impeachment proceedings. This is the nuclear option, used rarely, but its very existence creates fear that constrains executive behavior.
Fourth, the legislature must approve major executive actions. Treaties require legislative ratification. Significant appointments need legislative confirmation. Declarations of war require legislative authorization. The executive cannot unilaterally commit the nation or staff the entire government without legislative cooperation. Fifth, the legislature can pass laws limiting executive discretion, specifying exactly how laws must be enforced, creating procedures executives must follow, and establishing oversight mechanisms. Through legislation, the legislature can hem in executive action, even in areas where the executive has theoretical authority. How the executive checks the legislature. The executive's primary check is the veto power. When the legislature passes legislation, the executive can refuse to sign it, sending it back unsigned. This forces the legislature to either compromise with the executive's objections or build overwhelming support to override the veto. The veto is powerful because it requires the legislature to achieve supermajority support for controversial measures. A slim majority cannot impose its will over executive objection. This prevents narrow majorities from enacting radical or poorly considered laws and forces broader consensus building. The executive also has substantial agenda-setting power. Through public addresses, policy proposals, media attention, and the prestige of office, executives can shape what the legislature debates. They can focus national attention on particular issues, generate public pressure for or against legislation, and influence the terms of political debate. This isn't a formal check, but it's a practical counterweight to legislative dominance.
In some constitutional systems, the executive can dissolve the legislature and call new elections. This nuclear option prevents legislative bodies from becoming permanently unresponsive to changing circumstances or public opinion. If the legislature and executive reach complete deadlock, the people can decide which side they support through fresh elections. The executive also exercises significant discretion in how laws are enforced and implemented. while they must enforce the law, how they prioritize enforcement, what regulations they promulgate to implement statutes, how aggressively they pursue violations, and how they interpret ambiguous legislative language gives executives substantial influence over actual policy outcomes. How the judiciary checks both. The judiciary's power is more subtle, but potentially more profound than either political branch. The fundamental judicial check is the power to declare laws or executive actions unconstitutional, striking them down as violations of fundamental law that neither branch could legitimately enact or enforce. This is judicial review, and while Montesquieu doesn't explicitly describe it in modern form, the logic of separation implies it. If the Constitution divides power among branches and sets limits on what each can do, some institution must be able to enforce those limits. That institution is naturally the judiciary, interpreting the Constitution and invalidating actions that exceed constitutional authority. Judicial review is enormously powerful because it can stop both political branches simultaneously. Even if the legislature and executive agree on a law, even if it has overwhelming popular support, if the judiciary finds it unconstitutional, the law is void. This makes courts the ultimate guardians of constitutional limits. Courts also protect individual rights against majority tyranny. Even if democratic majorities want to violate fundamental rights, suppressing unpopular speech, discriminating against minorities, taking property without compensation, courts can declare such actions unlawful. This is counter-majoritarian by design. Some things are beyond majority reach because they violate fundamental rights that constitutional order exists to protect.
Courts interpret ambiguous laws, filling gaps the legislature left and limiting executive discretion. When legislation is unclear or executive regulations seem to exceed statutory authority, courts determine what the law actually means. This interpretive power shapes policy profoundly, while ostensibly just applying existing law. Courts can also issue orders directly commanding executives to act or cease acting. Through writs of mandamus, injunctions, contempt citations, and other judicial orders, courts constrain executive power immediately. An executive who defies court orders faces not just political consequences but legal ones, contempt charges, legal sanctions, and a legitimacy crisis. How the legislature checks the judiciary. Despite judicial power, the legislature possesses important checks on courts. First, the legislature must confirm judicial appointments. Presidents or monarchs may nominate judges, but the legislature can reject nominees they find unsuitable. This gives the legislature influence over the judiciary's composition, philosophy, and likely future decisions. Second, the legislature can impeach and remove judges for serious misconduct. While this should be rare and limited to genuine offenses rather than disagreement with judicial decisions, it prevents the judiciary from becoming completely unaccountable. Judges who are corrupt, criminal, or fundamentally violate their oaths can be removed. Third, the legislature can alter the structure of courts through legislation. They can create new courts, eliminate existing ones, modify jurisdiction, adjust procedures, change the number of judges, and restructure the judicial system in various ways. This structural control limits judicial power over the long term. Fourth, the legislature can pass new legislation overriding judicial interpretations of statutes. If courts interpret a law in ways the legislature didn't intend, the legislature can amend the law to make its intent clearer. This doesn't work for constitutional interpretation. You can't simply pass a new law overriding constitutional decisions. But for ordinary statutory interpretation, legislative override is always possible. Fifth, in extreme cases, the legislature can propose constitutional amendments to override judicial decisions they find intolerable. This requires extraordinary supermajorities and is very difficult, but it's the ultimate legislative check on judicial constitutional interpretation. How the executive checks the judiciary? The executive nominates judges, shaping the judiciary's composition over time. A president or monarch who serves long enough can transform the judiciary through appointments, selecting judges who share their constitutional philosophy and policy preferences. The executive also controls judicial enforcement. Courts issue orders and render judgments, but executives must enforce them. If executives refuse to enforce judicial decisions, those decisions become mere words on paper. An executive who systematically defies courts creates a constitutional crisis, but the judiciary's dependence on executive enforcement remains real.
The executive can also influence cases through the Solicitor General or Attorney General's office, which represents the government in legal proceedings. How aggressively the executive defends or challenges laws, what legal arguments it makes, what cases it appeals or declines to appeal, all these affect judicial decisions indirectly. Do you see the intricate web being woven here? Every branch has multiple ways to limit every other branch. No single institution can dominate because others have weapons to resist. Power is not just separated, it's actively balanced through these checking mechanisms. The beauty and genius of this system is that it harnesses selfish institutional interest for the public good. Each branch wants to protect and expand its own power. Each resents encroachment from the others. Each is jealous of its prerogatives and quick to resist when another branch oversteps. This mutual jealousy, this competition for authority, creates a dynamic equilibrium where no branch can accumulate tyrannical power because the others will resist. Their institutional selfishness becomes our protection. It's not a system that requires virtue, wisdom, or enlightenment. It's a system designed to work even when leaders are selfish, ambitious, and power-hungry. Because they're selfish and ambitious, they'll naturally defend their institution's authority against encroachment. Their vice becomes our liberty's guardian. This is Montesquieu's profound insight into political architecture, building a machine that functions properly even when operated by imperfect humans.